Please subscribe, like and share this content. It means a lot to us. Thank you in advance.
To U.S. Code Chapter 17A, Congressional Budget and Fiscal Operations. To U.S. Code Subchapter 2, Fiscal Procedures. To U.S. Code Part B, Federal Mandates. To U.S. Code Paragraph 658, Definitions. For purposes of this Part 1 agency, the term agency has the same meaning as defined in Section 551(1) of Title V, but does not include independent regulatory agencies. 2. Amount. The term amount, with respect to an authorization of appropriations for federal financial assistance, means the amount of budget authority for any federal grant assistance program or any federal program providing loan guarantees or direct loans. 3. Direct costs. The term direct costs, AI, in the case of a federal intergovernmental mandate, means the aggregate estimated amounts that all state, local, and tribal governments would be required to spend or would be prohibited from raising in revenues in order to comply with the federal intergovernmental mandate. Or 2. In the case of a provision referred to in paragraph 5A2, means the amount of federal financial assistance eliminated or reduced. B. In the case of a federal private sector mandate, means the aggregate estimated amounts that the private sector will be required to spend in order to comply with the federal private sector mandate. C. Shall be determined on the assumption that I. State, local, and tribal governments, and the private sector will take all reasonable steps necessary to mitigate the costs resulting from the federal mandate, and will comply with applicable standards of practice and conduct established by recognized professional or trade associations. And 2. Reasonable steps to mitigate the costs shall not include increases in state, local, or tribal taxes or fees. And D. Shall not include I. Estimated amounts that the state, local, and tribal governments, in the case of a federal intergovernmental mandate, or the private sector, in the case of a federal private sector mandate, would spend I. to comply with or carry out all applicable federal, state, local, and tribal laws and regulations in effect at the time of the adoption of the federal mandate for the same activity as is affected by that federal mandate. Or 2. To comply with or carry out state, local, and tribal governmental programs, or private sector business or other activities in effect at the time of the adoption of the federal mandate for the same activity as is affected by that mandate. Or 2. Expenditures to the extent that such expenditures will be offset by any direct savings to the state, local, and tribal governments, or by the private sector, as a result of I. Compliance with the federal mandate, or 2. Other changes in federal law or regulation that are enacted or adopted in the same bill or joint resolution or proposed or final federal regulation and that govern the same activity as is affected by the federal mandate. 4. Direct savings. The term direct savings, when used with respect to the result of compliance with the federal mandate, A. In the case of a federal intergovernmental mandate, means the aggregate estimated reduction in cost to any state, local, or tribal government as a result of compliance with the federal intergovernmental mandate. And B. In the case of a federal private sector mandate, means the aggregate estimated reduction in cost to the private sector as a result of compliance with the federal private sector mandate. 5. Federal intergovernmental mandate. The term federal intergovernmental mandate means A. Any provision in legislation, statute, or regulation that I. would impose an enforceable duty upon state, local, or tribal governments, except I. a condition of federal assistance, or 2. a duty arising from participation in a voluntary federal program, except as provided in subparagraph B, or 2. would reduce or eliminate the amount of authorization of appropriations for I. federal financial assistance that would be provided to state, local, or tribal governments for the purpose of complying with any such previously imposed duty unless such duty is reduced or eliminated by a corresponding amount, or 2. the control of borders by the federal government, or reimbursement to state, local, or tribal governments for the net costs associated with illegal, deportable, and excludable aliens, including court-mandated expenses related to emergency healthcare, education or criminal justice, when such a reduction or elimination would result in increased net costs to state, local, or tribal governments in providing education or emergency healthcare to, or incarceration of, illegal aliens, except that the subclause shall not be in effect with respect to a state, local, or tribal government, to the extent that such government has not fully cooperated in the efforts of the federal government to locate, apprehend, and deport illegal aliens. B. Any provision in legislation, statute, or regulation that relates to a then existing federal program under which $500 million or more is provided annually to state, local, and tribal governments under entitlement authority, if the provision I would increase the stringency of conditions of assistance to state, local, or tribal governments under the program, or 2. would place caps upon, or otherwise decrease, the federal government's responsibility to provide funding to state, local, or tribal governments under the program, and 2. the state, local, or tribal governments that participate in the federal program lack authority under that program to amend their financial or programmatic responsibilities to continue providing required services that are affected by the legislation, statute, or regulation. 6. Federal mandate. The term federal mandate means a federal intergovernmental mandate or a federal private sector mandate, as defined in paragraphs 5 and 7. 7. Federal private sector mandate. The term federal private sector mandate means any provision in legislation, statute, or regulation that a. would impose an enforceable duty upon the private sector except I. a condition of federal assistance, or 2. a duty arising from participation in a voluntary federal program, or b. would reduce or eliminate the amount of authorization of appropriations for federal financial assistance that will be provided to the private sector for the purposes of ensuring compliance with such duty. 8. Local government. The term local government has the same meaning as defined in Section 6501(6) of Title 31. 9. Private sector. The term private sector means all persons or entities in the United States, including individuals, partnerships, associations, corporations, and educational and nonprofit institutions, but shall not include state, local, or tribal governments. 10. Regulation. Rule. The term regulation or rule, except with respect to a rule of either house of the Congress, has the meaning of rule as defined in Section 6012 of Title 5. 11. Small government. The term small government means any small governmental jurisdictions defined in Section 6015 of Title 5 and any tribal government. 12. State. The term state has the same meaning as defined in Section 6501(9) of Title 31. 13. Tribal government. The term tribal government means any Indian tribe, band, nation, or other organized group or community, including any Alaska Native village or regional or village corporation as defined in or established pursuant to the Alaska Native Claims Settlement Act, 85 Stat. 688, 43 U.S.C. 1601 et sec., which is recognized as eligible for the special programs and services provided by the United States to Indians because of their special status as Indians. 2 U.S. Code Paragraph 658A, Exclusions. This part shall not apply to any provision in a bill, joint resolution, amendment, motion, or conference report before Congress that 1. Enforces constitutional rights of individuals, 2. Establishes or enforces any statutory rights that prohibit discrimination on the basis of race, color, religion, sex, national origin, age, handicap, or disability, 3. Requires compliance with accounting and auditing procedures with respect to grants or other money or property provided by the federal government, 4. Provides for emergency assistance or relief at the request of any state, local, or tribal government or any official of a state, local, or tribal government, 5. Is necessary for the national security or the ratification or implementation of international treaty obligations, 6. The President designates as emergency legislation and that the Congress so designates in statute, or 7. Relates to the Old Age, Survivors, and Disability Insurance Program under Title II of the Social Security Act, 42 U.S.C. 401 et sec., including taxes imposed by Sections 3101A and 3111A of Title 26, relating to old age, survivors, and disability insurance. 2 U.S. Code Paragraph 658B, Duties of Congressional Committees. A. In general, when a committee of authorization of the Senate or the House of Representatives reports a bill or joint resolution of public character that includes any federal mandate, the report of the committee accompanying the bill or joint resolution shall contain the information required by subsections C and D. B. Submission of bills to Director. When a committee of authorization of the Senate or the House of Representatives orders reported a bill or joint resolution of a public character, the committee shall promptly provide the bill or joint resolution to the Director of the Congressional Budget Office and shall identify to the Director any federal mandates contained in the bill or resolution. C. Reports on federal mandates. Each report described under subsection A shall contain 1. An identification and description of any federal mandates in the bill or joint resolution, including the direct cost to state, local, and tribal governments, and to the private sector, required to comply with the federal mandates. 2. A qualitative, and if practicable, a quantitative assessment of costs and benefits anticipated from the federal mandates, including the effects on health and safety and the protection of the natural environment, and 3. A statement of the degree to which a federal mandate affects both the public and private sectors and the extent to which federal payment of public sector costs or the modification or termination of the federal mandate as provided under Section 658A(2) of this title would affect the competitive balance between state, local, or tribal governments and the private sector, including a description of the actions, if any, taken by the committee to avoid any adverse impact on the private sector or the competitive balance between the public sector and the private sector. D. Intergovernmental mandates. If any of the federal mandates in the bill or joint resolution are federal intergovernmental mandates, the report required under subsection A shall also contain 1a. A statement of the amount, if any, of increase or decrease in authorization of appropriations under existing federal financial assistance programs, or of authorization of appropriations for new federal financial assistance, provided by the bill or joint resolution and usable for activities of state, state, local, or tribal governments subject to the federal intergovernmental mandates. B. A statement of whether the committee intends that the federal intergovernmental mandates be partly or entirely unfunded, and if so, the reasons for that intention. And C. If funded in whole or in part, a statement of whether and how the committee has created a mechanism to allocate the funding in a manner that is reasonably consistent with the expected direct costs among and between the respective levels of state, local, and tribal government. 2. Any existing sources of federal assistance in addition to those identified in paragraph 1 that may assist state, local, and tribal governments in meeting the direct costs of the federal intergovernmental mandates. And 3. If the bill or joint resolution would make the reduction specified in section 658(5)(bi)(2) of this title, a statement of how the committee specifically intends the states to implement the reduction and to what extent the legislation provides additional flexibility, if any, to offset the reduction. E. Preemption clarification and information. When a committee of authorization of the Senate or the House of Representatives reports a bill or joint resolution of public character, the committee report accompanying the bill or joint resolution shall contain, if relevant to the bill or joint resolution, an explicit statement on the extent to which the bill or joint resolution is intended to preempt any state, local, or tribal law, and, if so, an explanation of the effect of such preemption. F. Publication of statement from Director. 1. In general, upon receiving a statement from the Director under Section 650(a)(c) of this title, a committee of the Senate or the House of Representatives shall publish the statement in the committee report accompanying the bill or joint resolution to which the statement relates if the statement is available at the time the report is printed. 2. Other publication of statement of Director if the statement is not published in the report, or if the bill or joint resolution to which the statement relates is expected to be considered by the Senate or the House of Representatives before the report is published, the committee shall cause the statement, or a summary thereof, to be published in the Congressional Record in advance of floor consideration of the bill or joint resolution.